Welcome everybody to the IAPP web conference, The Right to be Forgotten, Managing GDPR Risk of Data Erasure for Businesses. Sponsored today by APARAVI. My name is Dave Cohen. I'm the IAPP's Knowledge Manager. I'll be your host for today's program. We'll be getting started with the presentation in just a minute, but before we do, I'd like to cover a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals who are the named registrants with one IAPP CPE credit. Others who are listening in can apply for those credits through an easy-to-use online form on our website. We'd also like to remind you that today's program is being recorded and will be provided free to registered attendees approximately 48 hours following the live event. At that time, the slides will also be available to you in PDF form through a download presentation link just below the recording viewing window. We encourage you to engage with us during the program through the chat function, which is at the top to the right of your PowerPoint slide window, and also the Q&A function, which is just below that, where you can post specific questions that you have for today's panelists. So feel free to just chat and engage with us freely in the chat function up above, and in the lower part, you can post the questions that you want to have our guests answer for you. And with that, let's move on to today's presentation. I'd like to introduce today's panelists. Debbie Reynolds, the Data Diva, is the founder and CEO and Chief Data Privacy Officer for Debbie Reynolds Consulting. Debbie, welcome to the webinar. And can you tell us a little bit about your practice and your professional background?
Sure. Thank you so much, Dave. I really appreciate it. So my work with Debbie Reynolds Consulting, I consult with companies that have multinational concerns, whether they have customers or business offices in different countries related to data privacy, data flow, and data movement issues. I also work a lot with companies that are doing things with emerging technologies and startups, as well as investor groups that are looking to put money into data privacy software. A lot of the work that I end up doing is counseling around the intersection of technology and law. So I do a lot with strategy as well as operational advisory for companies related to data privacy.
Terrific. Thanks so much, Debbie, for that. And joining Debbie on the panel today and our kind of moderator for today is Beth Winters. Beth is an attorney and a solutions marketing manager at APARAVI, our sponsor for today's program. Beth, welcome, and can you tell us a little bit about your role over at APARAVI and your background?
Sure, thanks so much, Dave. My name is Beth Winters. I'm a recovering attorney, and I'm the solutions marketing manager at APARAVI. I love combining my legal background, my business background, and my love for technology to help our clients with their unstructured data needs. And I'd love to tell you a little bit about APARAVI as well. We are the data intelligence and automation platform. We help organizations automatically reveal, comprehend, and automate their data assets using discovery and classification. APARAVI proactively and reliably reduces data risk through intelligent analysis and automated actions to enforce data retention, data quarantine, data archive, and migration through business-defined policies. We help you essentially find whatever it is that you need when you need it in a very simple and easy-to-use interface. And we help you create actionable intelligence to reduce your risks and costs. With 140 plus predefined classification policies, it's really easy to find what you need when you need it. And we have a number of different use cases for IT, compliance, legal, and business. And we can help unite all of these different departments to help you understand your data. So I'm really excited to be here today with Debbie Reynolds, and we'll be telling you a little bit more specifically about GDPR, and then at the end I'll go into how APARAVI helps with GDPR specifically. Overall, we help increase time to value. We help you gain control and expedite data integration with data intelligence analytics, We help you minimize costs, optimize storage, and defensively dispose of data with intelligent data management. And we help you reduce risks, demonstrate compliance, and gain control of your data with automated data governance and compliance. With that, I'd love to turn it over to our first poll question. Dave, can you help? Poll results. So about 50% are in legal, 20% in compliance, 8% in IT, 6% in cybersecurity or security, and the rest in other. This really helps us make sure that the presentation is well defined for you guys. So thank you, Debbie, for presenting today. I'd love to turn it over to you now.
Okay, excellent. Can you guys hear me okay? All right, so today we're going to be talking about the right to be forgotten, the legal issues and where things intersect in terms of the technical issues. So I don't know, my slide sort of disappeared, but I can continue to talk. So the right to be forgotten was quite groundbreaking, even though it had been in the previous data directive in the EU, because it was part of the GDPR, and the GDPR made sure that data privacy issues or data protection issues became a C-suite issue when it went into full force in 2018. The right to be forgotten is the right for a data subject to be able to have a controller erase their personal data without undue delay, and it shall be the obligation of the controller to make sure that they do that as it aligns with the rights of individuals. The right to be forgotten is, let me put this here. In terms of the reticle, it goes into more detail about the right to be forgotten, and it also includes information about erasing links, copies, or replications of data. The right to be forgotten creates a lot of technical challenges in terms of companies being able to find ways to forget individuals in terms of the data that they have. But a lot of these challenges start with data governance and the ability to be able to know what you have, be able to locate it, and figure out what's the best approach to be able to comply with the GDPR as it relates to the right to be forgotten. So where is the data? So data can be in all different places. This is a really big issue for companies in terms of finding the types of data that individuals may be asking to be forgotten. Also, the data can be anywhere, like on your website and CRM systems, data systems on premise and in the cloud, structured and unstructured data silos, which we'll talk about a little bit later. Legacy data systems, endpoints like laptops, desktops, mobile devices, and backup data systems. Backup data systems actually create an additional challenge where companies may be backing up data for security reasons so that they can make sure they have business continuity. They may be backing up data for archival purposes, and sometimes, depending on how the data is backed up, it may not be as simple to be able to gather that data. So for companies that do data backup systems in the cloud, it may be easier for them to get that data, especially if it's something that is a copy of something that's on an active system. But when those backups are, let's say they're tapes or in storage, those are things that companies really need to grapple with how they handle it. Typically, especially in a backup tape situation, obviously no one expects companies to spin up old backup drives and delete data from there. But in terms of just logistics, it's important that if that data were ever sort of spun up or needed to be reactivated again, you should make a note that there are data subject access data subject, erasure, or right to be forgotten requests that may need to be brought to bear on that data at some point if it's ever reactivated. The point is that if someone makes a right to be forgotten request, that the data should no longer be used maybe in the same way that it had been done previously. All right. So this is a lot of times that is partially because a lot of times the data that companies hold on individuals are in so many different places. So it's important that in terms of a strategy going forward, obviously companies need to be more cognizant of what user data they have, where those users are in terms of their legal rights, figuring out what are the best approaches for what needs to be deleted or not, and then being able to have mechanisms where you're communicating with the data subject about what their rights are and what are the best ways for them to be able to contact controllers and be able to get information back related to the progress of their request. Beth, did you have any questions? Can you hear me? All right. So I'm going to go, Beth, if we can we go to poll question number 2? Okay. Why are you having trouble complying with the right to be forgotten? This would be an interesting poll question, actually. So as the results are coming in, I'm sure many people on this call feel the pain from being able to try to adhere to these right to be forgotten requests. All right. Well, this is interesting. So 43% say it's really the process. 35% right behind it is technology, followed by not having trouble staffing and budget. So this is interesting. Thank you all for participating in this poll. I think I agree with that in terms of process. So process is difficult because no two organizations are alike in terms of how they store their data. You're typically working with people in different groups. There are different silos of groups and also information. So being able to do that is quite challenging. So in this statistic, it says 56% of organizations named locating unstructured personal data as their most difficult issue. So as I said before, there's structured data, there's unstructured data, there's obviously data in different locations that are being shepherded and managed by different people. So being able to locate the information is one of the first things that you have to do before you can even get to a situation where you're identifying personal data of individuals and then also being able to adhere to these right to be forgotten requests. All right. So what can be forgotten or not? Not everything can be subject to a right to be forgotten request. So here are some grounds for the right to be forgotten. So if you may have data about an individual that is no longer necessary, so it's important as you're collecting data or as you're taking a look at the corpus of data that you have access to or you're managing, to make sure that you're only holding data that is necessary. So that may mean maybe some preemptive purging of data or changing the way that you you collect data going forward. The data subject withdraws requests, consent. So in a case where consent is the basis that you're using for being able to retain data, you need to be able to answer back to the data subject and be able to withdraw consent, be able to erase data or forget about the data in some way if the data subject decides that they no longer want to have their data with you. If the data subject objects to processing, if it is not a legitimate basis. So again, you really need to look over what legal basis that you're using for collecting data and for keeping the data to know whether it is something that should be forgotten or not. The data is being processed unlawfully. So an example of an unlawful data process would be, let's say you collected the data for one purpose, but you decided to use it for another purpose. That may be a reason why someone may object to their data being used in that way. Remove data as a result of a legal obligation. So the legal obligation, especially for the EU and the right to be forgotten, is typically related to EU-related legal obligations. This does not automatically extend to legal obligations that are outside the U.S., where you would need some other type of legal basis or some other way to be able to get the data outside of the EU if it is needed. And removing data related to children. So parents can make requests on behalf of their children to have data forgotten about them, and children can make these requests once they get of a certain age. All right. So there are limits to the right to be forgotten. So not every request that's made for the right to be forgotten will be accepted. So some of these reasons relate to the right of freedom of expression, compliance with the EU legal obligation. Again, this does not necessarily extend outside of the EU. You may, if you have a legal obligation outside the EU, you may need to do other things to be able to get data forgotten. Matters of public interest and public health. This is very important now, especially because of COVID, where because we have a global pandemic and some information related to individuals is in the public interest and about public health. So there's probably more data or information, not just in the EU, but worldwide, where this information would not have ordinarily been something that would have been out in the public sphere, but it is now because of COVID. Archiving purposes in the public interest, scientific or historical research purposes, or statistical. Typically, let's say there's something that happened with an individual that's newsworthy in some sense, or it's something that has to be archived for historical purposes. Those types of things would typically not be forgotten. Establishment, exercise, or defense of legal claims. This is also a limit to the right to be forgotten. All right. So companies, when they get requests from data subjects to have data or information about them to be forgotten, there are situations where companies can push back on erasure requests. The main ones are if a request is manifestly unfounded in some way or excessive. So it's very important if you, let's say for instance, there may be like an activist or activist group, or let's say an individual makes multiple requests. It may be a situation where you may find it under the GDPR to be manifestly unfounded or excessive. But it's important in those situations that you document the reasons on a case-by-case basis in terms of why you feel that erasure requests are manifestly unfounded or excessive, because there may be a situation where the data subject can contact a regulator, and you may be contacted by a regulator to be able to give your reasons for pushing back on a particular erasure request. Beth, are there any questions before I go on?
I'm good. You're good.
Okay. So I'm going to talk a little bit about some couple right to be forgotten cases that are in the news. These are mostly related to the internet and search engines, but I'm also going to talk about cases related or talk about situations in terms of right to be forgotten for companies, not necessarily internet companies. So last year, Google won a landmark case. I think it started in 2015, but it got settled in 2019. And this is related to someone in France making a right to be forgotten case about data on the internet. At that point, when that case was filed, the question that they were trying to answer was, does a person have a right to be forgotten globally on a search engine? And this case basically said no. So it basically said that if Google or other search engines are asked to forget, quote unquote, about an individual or a certain thing, they don't have to make that change in all versions of their search engine around the world. They just do it in the countries in which the person resides. So this is a big victory for Google. And it also underscores how difficult these types of requests are. So when we talk about the right to be forgotten and the right to erasure, it sounds simple, but it's very difficult to do. And in this case, Google isn't necessarily erasing the data. They're basically delinking or removing the links that would make it easier for people to be able to find the information. So because Google is a search engine and it's not the internet, many of these delinking requests, it will make the information harder for an individual to find if they're using Google, but it doesn't erase the information from a website or wherever the data originated. So that's a really important thing to keep in mind. Also, Google is not the only search engine. So if someone had a right to be forgotten request made of Google and they want to make sure that it's erased from other search engines, they may actually have to make those also right to be forgotten requests with those other search engines, and there's no guarantee from one company to the next whether their right to be forgotten request will be accepted. So it gets relatively tricky from there. And then there was a case in Germany about a murderer's right to be forgotten. This is about a convicted man who had gone to jail and had served his time, got out of prison, and his argument was because he had done his sentence and his time that the information about him in that case should be forgotten, and a German court actually agreed with this person. And this is something I've seen also in other cases. Like I think there was a case in the UK, very similar, not murder related, but there were two men who had gone to jail in the UK, and once they served their sentence, is considered in the UK to be spent, meaning that can't be or shouldn't be held against the person because they literally pay back what they are supposed to do to society. So those issues happen on a case-by-case basis, and sometimes internet search providers will say yes or no. I think it's still early yet in terms of how these cases go, because it hasn't broken down, in my opinion, to be clear cut in terms of what cases or what individuals get right to be forgotten requests accepted.
So it seems like we have a question, Debbie, in the comments. Somebody was asking, does delinking, is that enough to be considered sufficient instead of full erasure?
Well, that's an excellent question. Actually, yes, delinking can be considered enough. I think it really depends on the individual and how far they want to go with this. Because data is gathered and captured in so many different ways. erasure or the right to be forgotten can be interpreted in terms of the technical ability of a company to be able to sort of limit the access to that data. So delinking, so in the Google example, because Google, let's say Google is creating a search engine that attaches to things that are on the internet. So delinking is all that Google will be obligated to do because they couldn't force the website where the original data resides to be deleted. So that may be a two-step process, but in terms of search engines, delinking may be enough. If you, let's say you have your own website and you're able to delete things, delinking may be okay. There are situations, let's say for instance, you have someone's data in a CRM system. You may have to delete certain information about the individual, but you may have to keep other information. For example, you need to keep a record of anyone who made a data subject access request, and especially if, let's say you have a service where someone has to sign up and they decide they want to, like, they want to cancel your service, you still need to have a record as a company that that person made that request. So it isn't erasing completely in a lot of cases. It is sometimes delinking. In the case of backup data, sometimes it's just not using that data because it may not be feasible for a company to incur an expense to restore a backup to delete that data. So the idea is you delete or remove or greatly limit access to information the best way that you can so that that data is no longer sort of in use or is less accessible.
And Debbie, we have one more question. Somebody would like to know if you can give an example of a manifestly unfounded request to be forgotten.
That's a good question. So a manifestly, let me see, let me go back here. A manifestly unfounded request to be forgotten. Let's say, for instance, someone did something that may have been of historical significance that they may not like. So that may be a situation where, because it say it was like in the public interest and it actually happened, that may be a situation where a company can push back and say, well, this is the reason why we're not gonna, delete this information because it actually, first of all, it's true, it happened, it has some type of significance in some way, and they can push back on that. So I hope that answers your question.
Other jurisdictions where they do have the right to erasure, like the United States, they may not uphold something like they did with the criminal case, where information and the right to free speech has such strong protection.
Yeah, so the U.S., we have freedom of speech, so not all free speech is free. I guess I could say it that way. So there are not everything that someone says in the U.S. will be something that will be subject to erasure requests. Obviously, we're a bit more litigious, and there are things like about libel and things like that. But erasure, in terms of the GDPR, is very different than what we have in the U.S. So right now, we don't really have erasure, except for maybe, let's see, laws like the CCPA, where they have information related to someone being able to access data, being able to have a right to have data corrected. I think that's coming in the next version, the CPRA, and then to be able to have the data deleted. But we don't, in the US, we don't have erasure requests in this same way. Obviously, there's nothing stopping someone from contacting a search engine anywhere in the world and say, hey, I want you to delete this data. But it doesn't mean that, first of all, it's up to the search engine if they want to do it. And then depending on the country you're in, you may not have a legal basis to request that.
If somebody is requesting that you remove their, billing information or something like that, but you still need that for, they're still a customer, you need it for billing purposes. Is that like an example of manifestly unfounded?
That could be an example of manifestly unfounded. Well, because it's part of a performance of a contract, so it wouldn't even be, especially if the person is still a customer, you wouldn't need erasure or right to be forgotten wouldn't apply in that situation. But let's say, for instance, they're no longer a customer, and then you're still using their data for some other purpose. In the EU, that is a problem, and that is something where even an individual shouldn't even have to ask for erasure of that information. So once you're no longer a customer, there should be mechanisms in place for companies to be able to purge that data and do so in a timely fashion. In the US, we don't have that, so there aren't, again, outside of things like the CCPA, possibly the BIPA law in Illinois, not a ton of regulations related to erasure.
We have a couple more questions, but you can go ahead on the slides. One was you mentioned that we need to keep records that we comply with the erasure and the question is, sorry, what records should we maintain to demonstrate our compliance with a DSAR request?
I think the records you should maintain is probably the date of the request, what you did in terms of, maybe you're reporting back to the individual about what you deleted about that person, and just file it. So if it ever comes up again, because chances are, let's say for instance, that person becomes a customer again, you may need to have that information. Also, if there's a situation where a regulator comes knocking on the door and is asking you about this information, you really want to be able to have it. So you just want to be able to know, this is the person who made the request, this is what we did with the request, and be able to have that in your records if it is ever requested of you.
We have one more question. Does the right to erasure extend to archival backups for disaster recovery purposes?
Good question. So the right to erasure may extend to archival backups, but it really depends logistically on how a company wants to handle it. So I would not advise a company to restore a backup to be able to delete information from an individual. But if there's a situation where, let's say, a archival backup is needed to be able to put data back in use, let's say a company had ransomware or something, and they had to restore a backup for some situation. If there's data in that corpus that would not have ordinarily been reactivated, that is related, that has data in it that from data subjects that had right to be forgotten requests, I think it's important to note that and be able to bring up that issue if that data is ever reactivated. I think there was a case that I saw, or an incident where I saw where a company was trying to figure out how they do right to be forgotten with the archival backup, and basically what was decided is, as long as the data sort of stays archived, you may not have to take any action on that data. So it's really trying to keep the data out of use, especially after an individual makes a right to be forgotten request. So you definitely want to be able to delete the data that's active and is readily available and easily accessible. But if there's data like in storage or in archival in any way, you may the act of not doing anything with that data may satisfy regulators that you know that this data is there, it's for archival purposes and you're not going to use it, but if you intend to restore it, you need to be able to address that at that time.
Thanks so much. I'm going to let you continue before we take any additional questions.
Okay. All right. I'll go through the rest of the slides and then we can go through the questions.
Right.
So, all right. So, how can companies comply with the right to be forgotten? This is such a tough thing to do, but here are some suggestions that I have for companies if they want to comply. So you really want to understand the rights of individuals about erasure. Again, like I said, the U.S. is very different than the EU in terms of people's right to erasure. So really understand the rights of individuals about erasure. So this really comes down to who your customers are or who are the individuals that you're interacting with, that you have their data. You need to really understand what the rights are of the people with whom you store their data. So some of the stuff may not apply to you depending on what countries people are from, but if you have customers that are in countries in the EU, you need to really understand what their rights are to begin with. All right, understand what personal data you have about data subjects. So this is very important to understand, how much data do you collect about individuals? Is that data necessary to keep? If there is a data subject access request, I think, I don't recommend that companies I recommend the companies be proactive as opposed to reactive. So that may mean understanding what data you have beforehand, before the individual asks, so that you can be able to say definitively either, yes, we have this type of data about you, or no, we don't have this type of data about you. Even I've seen people, for example, there are certain categories of data that companies will say, well, we don't collect this data about individuals. That may be a good thing to put maybe in a privacy policy to say, hey, here's the data that we do collect, and here's the data that we don't collect. So when there's a data subject access request, you'll be able to definitively say, we have these, 2 categories of data, and then we don't have these other 10. All right, so develop a data subject access request process if you don't have one already. So be able to have a situation where if someone ever wants to make a request of you, you need to have a process. So it can be, and you need to be able to have a way for them to contact you. So in some cases, that could just be an email address. Maybe there's a phone number. Maybe there's a link on your website where someone fills out a form. You need to have some way to be able to have that person make a request, and also be able to have a way to track when that request is made, because there are obviously time limits in terms of when you have to respond. I think it's 30 days you have to respond to a person. So the 30 days doesn't mean that you have to complete the deletion request, but you at least need to be able to respond to the individual, but you need to be on a path to be able to do the deletion once you figure out whether this person has a legal basis to be able to do it.
Right, but you can say something like, thank you for asking, we're processing it and we'll get back to you shortly, something like that.
Oh yeah, definitely. Right. And there are certain situations where you may have to have an extension, but that's listed in the GDPR. But you really want to be proactive in this situation where you need to know some things beforehand, before someone ever asks. So you need to know what types of data you collect, or people or not, and then also be able to time those requests.
And we have we're going to talk
develop a process,
and we're going to talk about the data mapping solution that we have that makes it really easy to look up what information you have about somebody and comply with those requests in a shortened period.
Yeah, exactly. So you want to develop a process to confirm the identity of the data subject if needed. So this may not apply to all companies. So let's say, for instance, you know your customer base, and like say for instance, they give you an account number or some way for them to be able to identify they are who they say that they are. If you don't have an easy way to do that, you may have to develop a process to confirm the identity of the data subject. And then there are situations where someone is making a request on behalf of a data subject. So let's say a parent is making a request for their child, or maybe a child is making a request of like an elderly parent. So you want to have a process in place to be able to confirm the identity, because you don't want that to create delays in you being able to process a request that is legitimate.
And this might just go back to just
All right.
understanding what types of data you collect on your users, right? So you would know if you can verify with a user ID, or if you need a record number, an email address, phone number, however, whatever information request. Yeah.
Exactly. Absolutely. Exactly. Be clear when the right to be forgotten doesn't apply. So this is very important. So you don't want to jump through a lot of hoops to fulfill a request if it doesn't even apply. So really understand from the type of data that you have, the people that you have the data from, even, does it even apply to this individual, and be able to have a way to explain it to them in very clear terms, and then keep a record of it if you're ever asked by a regulator to provide this information. All right. Develop a process to perform erasure. So there were, I think the majority of people on the poll said that they have the most trouble with process. So process is very important. Process is difficult because, again, you're working with a lot of different people within the company. You may have a lot of data subjects that you have data about. And being able to develop a process to perform erasure is very important. So I think even if you've never gotten an erasure request, you need to have a process if and when that ever happens, so that you're ready to be able to jump in and do what it takes to be able to assess that request. You definitely don't want to get in a situation where someone asks for an erasure, you don't have a process, and then the clock is running out in terms of you being able to respond or reply to that person. All right. Know what data is subject to erase requests. So not every type of data that you have is going to be subject to erasure requests. So again, let's say you're performing a contract for someone, like they're a customer, and that maybe their customer record or the information about like what they bought or something, maybe that's important to keep, but then maybe there are other things that you have about the customer that may not be important. So go through, make sure you have a good explanation, and tie your data or map it back to a legal basis for why you have it. And if you can't find a legal basis and you don't think the information is necessary, I highly recommend that people remove that data, because it's going to create a lot less burden for the company if they can make sure that they're streamlining their data that they capture and line it up with a legal basis. All right. Be prepared to respond to erasure requests within 30 days, as I said before. So that may not be, from the time the person contacts you to 30 days that the erasure actually happens. But you really need to be able to respond to the person in a timely manner. And if you can, obviously, perform an erasure request in 30 days, you definitely should do it. But if not, there are mechanisms where you may need an extension. Again, a lot of this is based on preparation and really having a plan or process in place, so that when these requests come in, you know exactly what you should do.
I see another question.
Acknowledge when you're...
Yeah, that's related to this. So when you're, how do you verify the requester is actually eligible to make the request under the GDPR, that they're actually an EU citizen? For example, are you allowed to ask for an ID to check that the request is eligible? What can you do?
It's open in terms of there isn't a lot, what's the word I'm looking for? it's all over the map in terms of how companies want to be able to verify the person is who they say that they are. Um, the idea is, let's say for instance, someone signed up for an account and they just use their email address or whatever, and then they make a DSAR request. You may, for example, say, well, I need you to give me your ID or something so we know that you are who you say you are. That may be fine, but then the company can't retain that data if that's the only reason why they have the data. So I guess with these DSAR requests, sometimes in order to verify identity, the company may be asking for more data than they had previously about the individual.
Right.
The key is if you use that data to verify them, you need to be able to delete that data after the request is
And that
done.
also,
Does that make
right,
sense?
and that also, can be really hard when, they may be submitting something via email. So it's important to be able to search for that type of information that may be unstructured. But for
Yeah, there was actually a controversial.
Go ahead. No, you go ahead.
Go ahead.
So for logging purposes, right?
It's actually a controversial.
just
Yeah,
for a log,
yeah.
you could write that they gave
Yeah.
their ID though, and not retain a picture of the ID or the ID number.
Oh, sure.
Right.
Absolutely. Anything that you capture for them to be able to verify themselves, that's more than what is necessary. Once you do the request, you don't need that data anymore. There's a controversial thing happening now, and I think it's happening in the U.S. for sure, but I think that they're doing this with TransUnion, I believe, in the U.K. or in the EU, where they're using the credit reporting bureaus. The thing where they ask you, like, what was your dog's name when you were 5 years old or something like that, or what street you lived on. They're using that as a way to verify identities of people. It doesn't always work right, but it's controversial because people don't want the information about their DSAR request or their erasure request somehow gathered or captured within those credit bureau
Right.
records.
And just to clarify,
right.
Also, it's not EU citizen, right? It could be EU resident or somebody who's in the territory at the time of the collection.
Oh yeah.
Yeah.
Right. Exactly. So definitely update your privacy policy. So this is really important, especially if there are categories of data that you do not collect about an individual. That should be clearly spelled out in your privacy policy, and it'll probably reduce the number of requests that you have. If someone looks at your privacy policy beforehand and says, oh, well, this company doesn't collect this data about me, so when I make a DSAR request, I won't include this information. So that stuff will really save you a lot of time if you can really spell that out in a privacy policy. I'm kind of rushing through here because I know we're getting at time and we still have some questions. That was my last slide. Do you have any other questions you want to ask? Beth?
Hi, sorry about that. I had my dog barking. So I think we had one more question that was, can you respond and initiate the erasure process within 30 days and then hold on to the data for an additional cooling off period before you actually permanently delete the information?
That's a good question. I've heard people say that. I think that you could do that if you wanted to in terms of a cooling off period. I would recommend, when possible, you want the erasure to be as soon as possible. Let's say, for instance, someone decided, okay, I want to make this request, I want to have this stuff forgotten, and then they turn around and say, well, I changed my mind, I want to be remembered now, or whatever. Maybe that process will be sort of a person like maybe reinitiating an account or something like that. I've not seen that a lot, but I know that in terms of, companies, let's say for instance, you get a lot of erasure requests, they may not erase the data right that second for that person. Let's say for instance, it may be in a queue and it's done like in a wave or whatever, but you need to be able to communicate with the data subject when the actual data is erased. So it's very important to do that. Make sure that you're communicating what is erased and when it was erased.
Great. Thanks so much, Debbie. I'm going to go ahead and just tell you a little bit more about how APARAVI can help with DSAR requests, specifically with GDPR. So as I mentioned before, we have 140 plus predefined classification policies, and that includes different country regulations in addition to the GDPR. There's CCPA, LGPD, HIPAA, PCI DSS. You can select the policy with the click of a button, and as a category, it will find any data that would be subject to the GDPR or that specific country in your database. So you can really drill down. You can also create queries and search by name, by country, and really find the information that you're looking for quickly and easily. You don't need to be an IT professional to be able to use it. So this really helps with those compliance and legal folks who are wanting to have more control over the process, or who might want to be able to look at the data from a higher level as well. So what types of data do I collect about my customers? How do I then create my my privacy policy? So you can drill into that information here. You can also use that information, like Debbie said, to be able to verify identity, knowing what types of data you collect. So the privacy policy and having the knowledge of your information, of your data from multiple data sources is really powerful here. The different data sources that we mine include cloud, on-prem, and endpoints. So you can also look at laptops to see if, or desktops to see if somebody had downloaded information that might be subject to GDPR, and delete that information accordingly so you don't have any security issues. So being able to find your information, find it quickly. We reduce cost and complexity by 40%. We reduce data risk, and we reduce data storage, your data footprint by about 60%. We also reduce the legal data collection time by 50%, and that includes DSAR response times. One of the other things that you can do here to demonstrate compliance is to create an export and print the log, and that would show which files contain information containing the data subject's name or other information. And then once you delete the information, you can create another printout, another CSV file showing that the information is no longer there when you put in the query. So a really great tool both for demonstrating compliance as well as for helping you with your DSAR requests in a timely manner, and for helping you define your privacy policies in the first place. And I'd love to invite you all to download the platform from the Microsoft Azure Marketplace, or you can also schedule a free data assessment or a remote install at aparavi.com. Hit Get Started. We give you 5 million files or 5 terabytes of data for free and 1 classification policy. So there's no risk to use a smaller subset of your data, look through your data and really see the value of APARAVI, and how APARAVI can help you find your GDPR data, other data that might be subject to data privacy under CCPA or CPRA now. And along the lines of CPRA, our regulations are updated when there are changes to the legislation because it's a cloud-based platform. So nothing else you need to do besides clicking the policy. And thank you so much, Debbie, for presenting with me today. Thank you, Dave. I'll hand it back to you.
Yeah, terrific. Thanks, Beth. Thanks, Beth and Debbie, for sharing your expertise with us today. A great engagement for the audience. I'd also like to thank the audience for joining us and participating. Lots of great questions coming in. Really appreciate this exchange of information. So as you can see on the slide in front of you, if you're listening to this as a live program, Beth and Debbie have both made their email addresses available. If you have any follow-on questions, feel free to click those links. They're live links if you're watching this as a live event, and you queue up an email and get that off to them. And if, as I mentioned before at the beginning of the program, if you are listening to this as a recording, look down below the viewing window and you can see a link that says download presentation, and you can download a PDF of these slides and get in touch with Debbie and Beth that way. Also wanted to extend a huge thanks to APARAVI for sponsoring today's program for us here at the IAPP. We depend on partnerships like this and sponsorships to keep the information flowing out to you, the IAPP membership. So thank you very much, APARAVI, for helping to support our work here at the IAPP. We very much appreciate it. And if you're listening to this program as a live program and have just a couple of minutes to give us some feedback, there's a link in front of you on the screen. If you click on that, it'll bring up a browser tab, and we've crafted a very short survey. It literally takes 2 minutes. Give us some feedback. Let us know how this went. And also, there's a field in that survey that lets you tell us what topics and issues you'd like to hear about on future IAPP Privacy Education Web Conferences. So click on that. Give us a quick some feedback, and we'd always love to hear from you and keep in touch. And as I mentioned at the beginning of the program, if you're an IAPP certified privacy professional, you have your certification with us, and you register through our website, you'll automatically be granted 1 CPE credit toward the upkeep of your certification with us. And if you're an attorney and you're listening to this program and you're wondering about continuing legal education, CLE credits, we don't pre-certify these programs, but they're often eligible depending on your jurisdiction. So you'll need to apply in your particular jurisdiction and put that application in. If you need any supporting materials, you can reach out to me. I can also connect you up with a colleague that we have in the programming department that is kind of our CLE expert, and so I can connect you with her, and she can provide information depending on what jurisdiction you're in. So with that, one last time, thanks everybody for joining us. Really appreciate you being with us today, and I'll take us to a program close.